There. So we are going to explain the Texas Realtors Residential Real Estate Listing Agreement, exclusive right to sell. This form was updated January 5th of 2026. So let's get into it. All right. So parties would be sellers' names. Broker would be my company and myself as the agent that will help you sell the property. This has the legal description and also the physical address of the property in question. Improvements. Anything that's permanently attached stays with the property. If it requires a tool to remove, it's attached. Okay. So it includes TV antennas, TV mounts and brackets for TVs and speakers, water softener system. Things that are not included would be washer, dryer, and refrigerator. Okay. Any accessories, for example, keys, mailboxes, curtains, rods, blinds, shades, drapes, remotes, also access codes for different things that are smart items. For example, if you have a security system that's connected to your smartphone, then you would need to also relay that information to the new buyer. If there's anything that you want to keep, we would enter it here. If it's part of an HOA, we would check it here. This would be the list price that we would put the house up for sale. Okay. And you also agree to pay any typical closing costs that are charged to the seller. So I will also present to you a net sheet. And in that net sheet, I'll have you initial it. It's simply an estimate, but it gives you a good idea of what kind of fees are involved. Okay. And then, of course, once we actually get an offer, I'll present a new net sheet based on the terms of that offer. This is the beginning and end date of the listing agreement. If you enter into another agreement before our agreement starts, then our agreement is no longer valid. Compensation by brokers. So the way agents get paid is not fixed and it's not standard. This breaks it down into two different options. Okay, every agent has charges different fees and operates differently. The way I operate is I charge the seller 6% commission, which you see here. And then half of that, which you see in paragraph 2, the 3%, goes to the buyer's agent. And that's where I am paying them to procure the buyer. Okay. So broker will retain amounts specified in 5A1 as broker fees if there is no broker that procures the buyer. So if I actually get the buyer, then I would keep the full 6%, because I'm actually working both sides of the transaction. I cannot represent both sides. I can only represent one, which would be you. Okay. Now, if you decided to only pay me a commission and not pay the buyer's agent, and then decide later to pay the buyer's agent, we would use this section B here. But that's not the way I operate my real estate business. Okay. I feel like it's much more in your benefit to provide the carrot to the buyer's agent. That'll make them work harder. That will make them get the deal to the closing table. Okay. All right, authorization to disclose. You give me authorization to tell the buyer's agent that you are paying 3% commission. It is only earned when you sell, exchange, agree to sell, agree to exchange, or agrees to option the property. So basically, I get paid when you sell it, or able to buy the property, acceptable price. Okay, and or if you breach the contract. So let's say we do all the work, we get you under contract, we get to the closing table, and then you decide not to pay me and you sell the property. You would still owe me a commission because I've still done the work. It's payable at closing. Now, let's say you get to closing and then you just say, I'm not going to sell the house. Well, at that point, you would owe me a commission because I've earned it. Or if you decide to breach this listing, usually I've never had a client walk away from a listing and not compensate me. Okay. Now there is a provision down here, which I'll go over in a second, that covers that. Broker's compensation is not payable if a sale of the property doesn't happen because without your fault, you weren't able to give clear title. You lost it because of foreclosure or other proceedings. Something happened to it and you were not able to restore it. Okay, like a fire or wind or something crazy like that. Okay. And then breach by, or let's say if the seller collects earnest money and you go all the way to closing and the buyer backs out and then you decide to sue them and you win, then you would owe me a commission or half of whatever proceeds you make from that. If it's less than the commission you would have paid me. So let's say If the commission you would have paid me would have been 6,000, that would have just been my side. And you sue them and you win and you only get five, then you would only have to pay me half of that five. So 2,500. So whichever the two amounts is less is what you would owe me. I've never had that happen. Let's hope it doesn't get to that point ever. I can get a referral fee if I refer you to contractors like movers, utility contractors, carpet cleaners, anything like that. Okay. I do not like to collect referral fees for those kind of things. I would rather that they do a good job for you than for me to collect extra money like that. Okay. If this listing terminates before the end of the contract, you are to pay me a $400 marketing fee. So let's say we put it on the market and we advertise it, and then you decide, you know what, I don't want to sell after all. Well, I'm okay with terminating the contract, but you would have to reimburse me for the marketing fees I've already spent, the time and the money and the energy I've already spent. All right, so there is a protection period. So basically, I have you have within 60 days after our agreement ends. If any of the buyers that looked at the property during the time you had it for sale with me decide to buy within 60 days, then you would owe me a commission. I have 10 days right after the listing ends to give you the names and numbers of the people who looked at the property. Now, if you wind up listing the property with someone else, then you would not owe me a commission. Okay. All right. Counties, all monies are paid in El Paso County. You authorize title to do the closing, collect monies, and make sure that the property closes. Notice regarding public marketing. If the property is publicly marketed, MLS rules require that we put it in the MLS with 1 day. It includes, but not limited to, websites, photos, videos, yard signs, digital marketing, um, uh, digital communication, MLS, sharing networks, okay, social media. Now, this shows that you agree to put it in the MLS, and a broker will file the listing with one or more MLS by the earlier the time required by the MLS rules, or 5 days. I believe our local MLS requires 2 days, but I enter it right away. Okay. Now, if you don't want it listed until so many days after the listing starts, we can enter that timeline here, but we have to give a reason. MLS requires that we accurately and timely submit all the information. Okay. So even after it closes, we have to update it because part of the rules is we are sharing information with other agents and appraisers and other real estate professionals. Okay. That way, everybody benefits from the sharing of information. Or you will not file a listing with any MLS or other listing service. Now, if you decide you don't want that, you have to know that the property will not be publicly marketed. It will not be included in the MLS database to share with other agents. Okay. They don't know the terms. The property will not be included in the MLS's download to various other websites. Real estate agents and members are unaware of the terms of the marketing. And then you also understand that if this option is checked and then you do decide to market it, then I'm required to still enter it into the MLS. Okay. Listing content, definitions. Listing content is photos, images, video, recordings, that kind of thing. Any descriptions, remarks, narratives, pricing information. Seller content is the information you give me to relay. Broker content is the information that I obtain to give to other agents. You give me the right to non-exclusive, irrevocable, worldwide royalty license to use the information during our listing and even after it expires, terminates, or it closes. All the listing content is owned by my company, and you don't have the right to any interest in it. So if you ask for uh, I usually don't have a problem sharing information on a property after it's closed, but for whatever reason, like you want video, if our listing agreement ends and you want a very expensive video that I pay for your next agent to use, I don't have the obligation to share that information. Okay. And this is part of our MLS rules. Um, all right. So you authorize access to the property within reasonable timing. And you do give me the right to use showing time. to advertise, to schedule showings, and you do authorize or give me the right to make copies of the keys. Here we place whether or not you decide if you're going to put a lockbox on the property. If it is tenant occupied, we will need a separate form for them to sign authorizing use of a lockbox or access up to the property. When authorizing access to the property, you understand that unless we cause any kind of damage, we cannot be held responsible. You agree to hold us harmless for any claim, personal injury or damage or other loss. Okay. Reserved. This is a little placeholder. This just basically says there's no other hidden provisions in this contract. And if there was any other provisions, we would enter them here. Number 9, intermediary. This says that that broker may show the property to interested buyers. Okay, if that buyer presents an offer and that agent is within our company, then our our broker acts as an intermediary. Okay, in that situation, an agent could be assigned to work for the seller only, and an agent can be assigned to work for the buyer only. Okay, of course, you already have your own representation. And broker may notify seller that broker will make no appointments. Okay. So if you don't want intermediary, then basically you're saying that you don't want any agents within my office to show the property, which does not benefit you. The more people you can get into the property, the better. If my broker does act as an intermediary, they may not disclose any to the buyer that the seller will accept less than the asking, unless the seller gives a written agreement to that. My broker may also not disclose to the seller that the buyer is willing to pay a price greater than what they put in writing, unless there's a written agreement. Broker may not disclose any confidential information that the seller um, or the prospective buyer specifically instructs the buyer in writing not to disclose. Okay. The Real Estate License Act or a court order or information material related to the condition of the property. Okay. That's required. Okay. If it's required by these, then they have to present it. They may not treat any party dishonestly, and they may not violate the Real Estate Act. Confidential information stays confidential even after the closing of the sale. Okay, unless required by law. You authorize us to use all reasonable efforts to market the property for sale, get a buyer, and help you negotiate the sale. If 6A1 is checked, which is you don't want it on the internet, you can check you don't want the listing on the internet or you don't want the address on the internet. You also understand that if you check these, consumers who do searches may not see or will not see your information about the listing in their response to their search. So if you decide not to advertise it, then you probably are limiting your buyer pool tremendously. You are also willing to look at buyers that are conventional VA, FHA cash, or Texas Vet land program financing. And we also may advertise the property with photos, visual images, media, video. You agree to let us put a for sale sign on the house, furnish a competitive market analysis, or also call it a market snapshot for buyers who are asking. Disseminate information to other agents, so disclosures that are required by law. Obtain any information from your mortgage company. Accept and deposit earnest money with title as according to the contract. Disclose sales price and terms or other real estate professionals, of course, after the closing. Respond to any inquiries by buyers about the property. Okay. And we will not disclose any other competing offers if they ask if we have another offer on the table. We cannot tell them what the other offer is for. You give us the right to advertise during the listing if it went under contract and even after it's sold. Place the information on the MLS or other internet-based systems so that people can see and we can share that information. We are not authorized to sign any document on your behalf. You also agree that you have clear title to the property, okay, and any improvements and fixtures unless they're rented. Seller is not bound by another listing agreement. Not Keep any pool or spa in compliance with city ordinances. No other person has a right to purchase, lease, or acquire the property, um, or have another agreement. Seller is current and not delinquent on any loans, home equity, home improvement, home association, taxes. And if you are, we have to enter it here. You are aware that you are not aware of any liens on the property except for that. You're not the subject to the jurisdiction of any court. All information is true and correct to the best of your knowledge. If you have a relocation company, we would enter it here. The information that we're entering does not violate, infringe on the rights of anybody or copyright. The information you give us, I should say. Seller is aware the property being in a municipal utility district or private public improvement district. If, for example, if you were in Horizon and you were part of that special uh, uh, utility district for water, or you're in Far East El Paso and there's a public improvement district. There is, you would enter it here. Cooperate with us in the showing, marketing, and sale, not rent or lease, not negotiate with anybody directly, not enter into another listing agreement or leasing agreement. If you be care, if you check 682, promptly inform in the event that you become aware that the property has been publicly marketed. Like, let's say you didn't want to market it publicly, but then your kids decided to start advertising it. You have to let us know immediately. Maintain any pool or equipment according to the city ordinances. Provide us with copies or lease or rental agreements or move out date for any tenant you might have. Complete any disclosures required by law. And if anything changes, material changes with regard to the property, you have to let us know and we have to update and amend those notifications. If the property becomes vacant, you have to let your insurance know because you might have to put a vacancy clause on there. Otherwise, you run the risk of not having coverage. We are not responsible or liable in any manner for personal injury or loss or damage to the property resulting from acts of omission, your negligence. Now, if we did something like negligent, that would be something different, but we also cannot be held we're not including but not limited to injuries and damages caused by other agents. So if somebody else falls, we can't be responsible. Inspectors, appraisers, other agents, other brokers or their associates who have information about the property on their website. So if, for example, you go on Zillow and something is wrong there, I can't be held responsible because by the time I entered into the MLS, I would have had your approval on the information that I submitted. Now, if Zillow incorrectly uploads the information or transfers it, I can't be responsible. I'll do everything I can to get it corrected, but I cannot be responsible. Um, Acts of third parties, vandalism or theft, freezing water pipes, dangerous conditions on the property, your non-compliance with any law or ordinance, and your negligence or otherwise. You agree to protect, defend, and indemnify and hold us harmless from any damages, court costs, attorney fees, expenses that arise from your negligence or failure to disclose information or giving incorrect information. If we had any special provisions, we would enter it here. If you do not cooperate with us in the facilitating or marketing or sale of the property, then you're in default, and then you would owe us a commission, and we would terminate. And if the sales price is not determinable in the event of an exchange or breach, then the listing price will be the sales price for those computing compensation. Okay. Now, if broker breaches the listing, if I breach the listing, broker is in default and the seller may exercise any remedy under law. Mediation, if we come to a disagreement, we agree to go to mediation first. We will split the fee. And if we do wind up in court, the loser may have to pay the winner's attorney's fees, depending on the court rulings. The other addendum we're adding to this is information about brokerage services, the seller's disclosure notice, lead-based paint if applicable, request for mortgage, information on insurance, and authorization to disclose and advertise certain information. If any of the other things that are not checked apply in your situation, we will check those boxes. This is an entire agreement. Nobody may make any changes to the agreement without written consent. Neither party may assign this listing without written consent. It's binding upon you and your heirs and anybody else listed or anybody assigned. All sellers executing are jointly and severally liable for the performance of all its terms. So if it's a spouse, husband and wife, but both of them together and separately are liable for the performance of the contract. Texas law does govern the interpretation, validity, performance, and enforcement of the listing. If the court finds that any part of this contract is not valid, the rest of the contract is still valid, and any notifications must be done in writing, listed on paragraph 1. Additional notices. We cannot discriminate based on race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity. Okay. Broker advises seller to contact your mortgage to make sure that the information you have is correct. We advise you to review information that we put in the MLS, which I will do with you. We advise you to remove secure jewelry, prescription drugs, firearms, other valuables, or weapons. We advise, and also to advise the tenant of it, okay? We advise you to consult with an attorney before using any kind of surveillance equipment because we can't be responsible if the law doesn't allow it and then the buyer sues. And if you do record, let us know, and so that way we can let the buyer's agent know as well. Statutes or ordinance may regulate certain items like pools or septic tanks. Okay, so you need to make sure you check with those things if that's applicable. If the house was built before 1978, there's a good chance that there's lead-based paint in there. We have to disclose if you have any knowledge. We have to give the pamphlet on lead-based paint prevention, deliver all the records you have, okay, and provide the buyer up to 10 days to get it inspected for those hazards. If the seller, you are a foreign national, we need to disclose it because the IRS may hold back a portion of the proceeds. So this is where you would check is or is not a foreign person. And we also advise you to not share your banking information with anybody, okay? You will get an email from title letting you know if you need to pay anything to title, which is unlikely. It's more likely on the buyer side. But in the event that you do and you get an email that says, wiring instructions have changed, do not answer to that email. Pick up the phone and call me and let me know, okay? This is the end of the listing agreement. If you have any questions, let me know, and I'll talk to you soon. Bye-bye.